Thanks everyone for joining. Wanted to spend a little time talking about the independent contractor landscape and how the new tax law is going to affect it, and perhaps change the way that we view it. So I think we're going to just talk a little bit about a snapshot of that. We'll talk about the provisions associated with the tax plan, then its impact on both employers and independent contractors, and then some of the things that all of us can do to prepare for that changing landscape. You can advance, Ollie. So conceptually, what we're seeing right now is that there are 60 million folks who are working in a contingent manner in the United States now. And that number is increasing, it's changing. And so one of the things that we want to make sure that everybody understands is that as time goes by, we're going to be seeing a larger and larger proportion. In fact, estimates of 50% of the workforce is going to be contingent within the decade. And so as a result, we're going to have to change the way we both view employees and the way employees view us. So what's new is, workers have sort of traditionally wanted stability and something along the lines of meaningful work over a long period of time, but that's changing. What they really want now is an alternative to full-time employment. They want work that means something, and they want to be able to be flexible in their scheduling and in their control over themselves, really developing their own workforce brand. Employers want to change from what used to be a sort of a fixed cost model to a variable cost model. And in so doing, they are changing from full-time labor to non-employee labor. And finally, realistically, only using full-time employees as a last resort. The impact of that is interesting. So next slide, Holly. The impact of that is interesting. So Accenture believes at some point in the next couple of years, 10 years, that at least one of the Fortune 2000 is going to end up with a C-suite and nothing else. Everybody else will be non-employee labor, outside services or ICs or temps. And that changes the outlook for the way that all of us have to view the relationship we have between the work getting done and the companies themselves. So that all of that is to set the stage and provide context against what we're going to talk about. And I'm going to turn it over to Rob to talk about the specific provisions within the tax cut and the Jobs Act. But bear in mind that this changing landscape provides a context in which to view all of these changes. Go ahead, Rob.
Right. Thanks very much, Neal. Yep. Thanks for having me. So it's against the backdrop that Neal mentioned that we're going to evaluate the impact of this new tax plan, particularly how it's going to affect companies and workers and what companies will need to do to prepare for the likely uptick in independent workers. Briefly, what is the Tax Cuts and Jobs Act? Well, it's a lot of things. There are many, many provisions that we're not going to be delving into. A couple of them that are relevant here we'll look at in particular. But generally speaking, it's been called the most sweeping reform to the tax code since 1986. Literally, it amends the Internal Revenue Code to reduce tax rates, modify policies, credits, and deductions for individuals and businesses. And keep in mind, too, that this takes effect for the 2018 tax year or for next year. So the taxes that we're all going to be filing in April, if we haven't already, these are unaffected. The other thing to keep in mind, too, is that many of these provisions sunset or expire by their terms in the year 2025. But within these several years, there's going to be a lot of developments. Thanks, Holly. You can go to the next slide. So what are some of the business structures that will be affected and that we're going to talk about today? There are about four that we really want to focus in on, and without getting into a sort of a business entities discussion or formation discussion, just a little bit about these entities. Many of you listening work with these entities on a daily basis. I know I do as well. So you may know a lot of this already. But we're going to be looking at pass-through entities and non-pass-through entities. So when we talk about pass-through entities, we talk about entities and business structures for independent workers, in this case, where the business profit and loss flows through or passes through directly to the individual's tax return. This is in opposition to something like a C Corp, which is, think of it as your really large business structure, your global, your multinational businesses, where there's double taxation. So in other words, there's taxation at the corporate level, and then there's taxation at the shareholder or individual level as well. So keep that in mind. When we talk about sole proprietors, we're really talking about individuals who own their own company and they do their business in their own name. They do it under their Social Security number. Typically, they don't have an EIN or a TIN. And again, the profit and losses from their business flow through directly to them. For essentially, there's no separation between the individual and the legal entity. This is in opposition to an S Corp or an LLC. Briefly, S Corp is something that you do have to form in your state. There are compliance requirements, annual requirements, so there's a little more setup for an S Corp and a little stricter operational practices. But again, it's pass-through or flow-through taxation. It ends up on the individual's or the owner's individual tax return. An LLC, this is what we see a lot of, and this is what I think we're going to see a lot more of. An LLC gives the owner of the LLC a separate legal entity. In other words, if something was to go wrong in their business or they were to be sued in their business, their personal assets wouldn't be at stake there. So it is a little bit of a separate legal entity from a sole proprietorship where if something was to go wrong in that business, their personal assets could be at risk. LLC is what we know is very, very easy, very low barrier to enter into using an LLC. They're very cheap. If you were to Google form an LLC now, you'd get probably over 1 million hits in under a second. So I'm thinking that this is the one to be cognizant of. And the way you're going to see it is instead of, heretofore you've probably been paying, for instance, Neal Bhamre, the individual. Your company may find itself, soon paying Neal Bhamre LLC or NB LLC or the like. So that's a little bit about the entities and the way the taxation works. You can go to the next slide then, Holly. And how that matters is because there are two really key developments on the next slide there that we're going to focus on today. And that's going to be the reduction in the corporate tax rate, and this would have an effect on those C Corps I referred to, and then the pass-through entity deduction. Now, the corporate tax rate deduction is going to be slashed from about 35% at the highest tax rate to 21%. There's much speculation about what this is going to mean. Will this make domestic companies more competitive with their foreign competitors? Will this encourage domestic companies to remain at home instead of going overseas? We don't know. As it affects companies, there is some speculation that this corporate tax rate reduction could possibly lead to such things as increased budgets for companies to go out and engage contingent workers. Could possibly lead to more money to pay contingent workers and thereby making your company more competitive and grabbing some of that scarce talent out there. We don't know, but these are some of the things that could happen. And the really big one that I think we've probably all not been able to avoid, and for good reason, is the pass-through entities. So that would be that LLC, those sole proprietors, S Corp. They're going to be allowed to deduct 20% of their taxable income every year on their tax filing, right off the top. This is the big one that there's a lot of talk about, and we're going to go further into that. So I won't say everything here about that now. But certainly it's an enticement to become an IC if you are not one yet. And certainly if you're a company, it's a further inducement to creating more ICs, more contingent labor, and moving away from a full-time employee model. Two things to call out here. There are exclusions to who can have this deduction. It's not for everybody. There are certain professionals, such as lawyers, doctors, engineers, that are not going to be, they're carved out of this legislation. Additionally, there are thresholds, income thresholds, that carve out certain people too. I believe for a single individual filer above $157,000 annual income, you're not going to benefit from this 20% a tax deduction. Also, if you're married filing jointly, I believe the threshold is more around $315,000. So once it gets beyond these thresholds, and this population of workers, higher compensated workers, are not going to be benefiting from this tax deduction. So a couple things to keep in mind while we hear all the generalities about this. Let's consider some of the interesting exclusions that have yet to be worked out and fully analyzed. That's fine. The next slide then.
Yeah. So before we dive into the details and Rob shares with us the knowledge he's gained, there's a poll that we'd like you to participate in. Essentially, how will the new tax plan impact your contingent workforce strategy? And knowing as much as you know now, we'd like to get a baseline on what you know. Holly?
All right, thanks so much, Neal. I'll go ahead and show those results to everyone. So, Neal and Rob, what do you think about what's coming through?
I'm in no way surprised. Yeah, and we can only hope that there is a little less of not sure. But this is par for the course with new and complex legislation. We are all to some extent not sure. I think the most important thing we can leave with is information, on how to move forward that we didn't have. Some of the things that go beyond the headline. Go ahead, Neal.
No, the only thing I was going to say is I perceive that the folks who are answering A, make it easier, are believe that this will encourage folks to hang their own shingle, making them more available to the marketplace. And I think that's generally true, although I'm watching that number get smaller every time I speak.
Very encouraging, Neal. You're talking them down.
Exactly. That said, I think it's going to be. I think it's true. I think there'll be more folks available to organizations to acquire, but I think it's also going to be more complex to acquire them. So let's explore that.
I agree with that. Just to piggyback on that for a second, Neal. I think what everyone's facing in the C-suite, right? One of their biggest issues is still talent scarcity out there, and so I think that a good effect of this here is that you may have less of a talent scarcity for certain demographics of independent workers because more will be out there, and I would factor in that those income thresholds that I mentioned to you. So there still could be a talent scarcity at the top end of your independent contractor workforce, but in that middle end that could certainly benefit from this deduction. I think suddenly this scarcity is going to start to drift away a little bit.
Okay, Holly, I think we can. So, look, with any complex legislation and with any change like this, there's winners and losers, and I think the arguments for and the argument against largely stem from where you are. But we wanted to share a little bit of what we've seen in the marketplace in terms of arguments for and arguments against. So let's start with the arguments for, right? So generally speaking, you're looking at a relative benefit for small businesses, as Rob pointed out. Once you reach a certain size, and if you're not a real estate developer, these benefits sort of cap out. And it does encourage flexible work options, which is I think, as we mentioned early in the presentation, something that folks are looking for. And then generally speaking, you're looking at a reduction in the corporate expense, which will allow for the engagement of really more independent contractors in this manner. But it does come with some negatives. The general worry is that folks will be, and you can advance, Holly. General worry is that folks are going to use this as a method to shelter income from tax. And it's certainly true on the real estate development side, which I'm sure shocks no one. And so there's some worry about that. More specifically, I think as a general statement, our employment protections are generally based on having a large number of us working in a W-2 manner, protected by the DOL and our state agencies, and this will as the workforce mix changes from W-2 as a primary model to non-W-2 as a primary model, we'll end up with a we'll end up with diminished protections, I think, as a general rule. And then of course the argument, the fundamental argument against lower taxes is that there just is less revenue, which is problematic in a bunch of different ways if expenditures remain flat. Rob, you want to talk a little bit about that part?
I do. In fact, the arguments against, obviously as a lawyer, I could argue both sides of things, and so I suppose the arguments against, I'll argue against in a way. So when it comes to serving as a tax shelter for wealthy individuals, while there's merit in that statement, if you keep in mind the income thresholds, you're going to have to dutifully game the system a bit to really take advantage of that. Some of these exclusions and thresholds will cut against this really being a tax shelter per se for wealthy individuals. I would also say when it comes to the employment protections and safety nets, this is a huge issue that's been out there in the main for several years. And there are people out there, in fact, I think it was last week or a couple of weeks ago, the Uber CEO co-penned a letter in Washington State, asking for portable benefits or benefits for ICs which mirror to some degree the social safety net benefits that W-2 employees have always had, but become portable. In other words, a contingent worker, an IC, can take them with them from gig to gig, job to job, engagement to engagement. Also, there's Senator Mark Warner out of Virginia, who's been very much, right now he has a bill out there for to try to get $20 million to investigate portable benefits for contingent workers. So I feel like this has been out there as a conversation, and so the social safety nets, all this does, I think, is move us more towards looking at what we can do to fill in some of these benefits without really damaging, where the workforce is moving to. As far as lower tax revenue, and I think we'll get to that a little bit more. Again, depending on what analytical pundit you subscribe to, you'll find studies that cut for and against. In other words, lower tax revenue puts more money in people's pockets, and then those people go out into the economy and spend that money. So also goes both ways. But certainly those are some of the arguments against. But just some counterpoints there, Neal.
Yeah, no worries. I think the next slide illustrates why you're happy about the tax law.
Right. So there are some winners and losers here. Neal's obviously referring to the lawyers' fees. Lawyers always win, right? So new legislation comes out, and people need to analyze that. People need to go to lawyers to really find out if this is the right thing for them. Should they enter into the independent contractor model, or should they remain where they are? Well, starting with the the down arrow there, a couple things we just talked about, the government tax revenue decreases. As I said, that the tax revenue decreasing, for instance, part of the tax decrease for C corps is there could be more of a reinvestment in domestic economy. Some of these companies could put some of their money back into America. At least that's some of the hopes. And then the revenue decreasing, again, if you take 20% as a deduction, you have more money to spend, in this economy, and so that there could be a little bit of a boom there, and not quite a bust. Certainly two ways to look at that. There's also been talk about, well, will this, hinder new 401k creations? The argument there is that if I can take 20% off of my annual tax filing, I'm going to get that money now to put in my pocket. Why should I instead fund a 401k that becomes taxable to me when I withdraw those funds? So that's the argument there. However, we've got to think about this in a sort of a whole view here. 401ks are more of a long-term planning device. And this 20% tax decrease is about a short-term thing. So I would say to anybody looking at this, they really need to do the math and look at what's really going to be right for them short-term, long-term, etc. Let's also keep in mind that for 401k creation, to the extent that employers use this as sort of a competitive device or a benefit to their employees, to the extent that full-time employees still exist, right? They're not doing this as sort of a tax shelter move. They're doing it more as an employee benefit. So, again, more to see as this kind of plays itself out. On the winner side, yeah, people are going to be forming LLCs, right? So these third-party service providers that form them, your LegalZooms and whatnot, are going to get an uptick there as people kind of jump off the fence or jump over the fence to incorporate. Feel free to go to the next slide, Holly. So there's definitely, despite all of the conjecture, and while we have to see how this, this legislation plays out over a little bit of time here, there isn't any doubt that this lends itself to the gig economy trend. There will be more independent contractors out there. We're going to talk a little bit more about that, but for companies, I think one thing to be cognizant of is that with more independent contractors, think of them as newborn independent contractors coming out there, they actually may be looking to you for guidance because they really may not be set up. They're not going to have a lot of experience with that. So you may actually get more questions about how they should engage. And I would say, be cautious at the outset if you do start to get questions about being an independent contractor. My suggestion there is to refer them to, websites like the Department of Labor or the IRS, for more information, rather than start advising them in particular, because you don't want to give the effect of ending up looking like you're having a bit too much direction or control over them. Just want to keep the delineation there. And we'll take a closer look here at some of the tangible impacts if you'd like to move on there.
Thanks, Rob. So we've got another poll. Wanted to get a feel for how you guys are managing your current non-employee labor spend. Thank you, Holly. So what I'm seeing is a couple of things here. One is that percentage is actually lower than expected, and I think, Holly, correct me if I'm wrong, but I think the question is actually embedded in the poll, so you guys can do that. Let's go to the results here. Okay, so a little more balance now, and I think I'm seeing an artifact of fewer people responding. But generally speaking, most of you guys are looking at a quarter of your workforce or less is managed through non-employee labor or through the SOW model. I would be surprised if that was actually true in terms of an audit. What we experience in our customers is that it's something like 3 times as many SOW workers as there are sort of regular temp workers, and we're used to seeing regular temp workers being something like 20 to 30% of a company's overall workforce. So it would be surprising if it was that low. Rob, you have any comment on this?
No, I don't agree with you there, Neal.
Okay. All right, so let's go on to the next segment here. So traditionally, firms have sort of managed their non-employee spend in sort of 2 ways, right? We've had staffing firms that provide temps or contingent labor on an as-needed basis, at-will employees, et cetera. And then we've had sort of large consulting firms that help us solve major problems like a infrastructure change or a business process remodel. Firms like Accenture or IBM. What we're seeing now are trends towards, and you can advance a little bit, Holly. What we're seeing now is that ICs and SOW contracts for smaller firms are taking up a larger and larger percentage of our non-employee labor spend. Generally speaking, we're seeing that as solving specific problems in the IT arena or creative, et cetera. But it's starting to bleed through across multiple enterprises. The impact here is interesting. So one, we all know, or we've become used to buying contract labor through our temp agency partners or our MSP firms. We already knew how to hire McKinsey, but we're needing to understand and develop a third path. And that third path is around the smaller firms that have genuine skills that we need to be successful as business owners, but who don't really cleanly fit into either temp staffing or giant consulting firm. When we procure these services, we've been used to being able to demand things like very high levels of insurance, indemnifications around deliverables that smaller companies, right, 2-man companies, 5-man companies, aren't able to do. We need to create a path that allows them to be procurable. That said, what we've seen in our practice is that some firms don't open that third door, and they lose out on access to this talent. Now, combine it with what Rob just talked about, or spent the last few minutes talking about, in terms of the number of folks and the upward pressure on the creation of these small firms. We're creating some of us are creating a situation where that part of the talent marketplace is becoming invisible to us, and it's something we have to do to change, because we need to be able to acquire those services without demanding unreasonable levels of insurance, unreasonable terms and conditions, unreasonable payment terms, which is another problem. IBM can afford to take 180-day payment terms. Joe Bob's server development guy can't. All right, next slide, please. So the other element to consider here is that those workforce dynamics are changing, right? We now need a lot more interaction between ops and procurement, ops and HR, because these guys still need, ops still needs to get the work done, right? And if we don't open that third path, we're going to squeeze out these small companies, and we're not going to be able to get that work. As more and more folks hang their own shingle, it becomes problematic for those people who whose jobs are on the line for P&L creation, and who cannot acquire the services they need because they can't acquire those individuals that they need. Next slide, and I think this goes to Rob.
Yeah, exactly. So, going from that is you see the slide, no free pass. So we've talked about tax revenues, and we'll talk about that from a slightly different angle here. But there's one take-home, well, there are many take-homes, I hope. But, one take-home to remember is we have new sweeping legislation. But we have no new tests for independent contractors, who they are, what they are. Okay, there are some things out there. And there are no new tests when it comes to rooting out worker misclassification. So while this deduction is going to bring in an influx of many, many more independent contractors, the misclassification tests that are out there, the way that that's investigated and penalized is exactly the same. The IRS tests for finding misclassification are not different. The Department of Labor has had many changes, and in a way, some of those changes could be its own webinar. They still are looking for misclassification on the state level. These things are not changing. So do keep in mind that while we have this sort of influx, this means that the risk of misclassification can actually go up. If we look at a decrease in tax revenue, there could be a tax gap here that could be looking to be made up. So one thing when misclassification first kind of came to the fore, a lot of it was around the fact that there were several $100 million in a tax gap that was credited to worker misclassification. So enforcement became a paramount thing to close that gap. Now that we're going to have more and more independent contractors in there, and there's a tax, revenue decrease, it could be the occasion where, these enforcement agencies actually feel like that is actually more to go out and get. This isn't to create any fear. Rather, it's an opportunity to take time now to, adjust, investigate any of your compliance procedures, and make sure that you're going to be out there ahead of anything that's coming. Okay. And then, of course, there's the impact on independence. You can go to the next slide too, Holly. So the provision may provide the necessary bump for workers who are on the fence about incorporating, but on the worker side, they've got to consider all the consequences, all the costs of incorporation. Certainly, if you're a sole proprietor and you walk out, there aren't any costs to incorporate. You're not incorporating. You're doing business in your own name. You just walk outside your door and decide one day you want to sell ice cream cones, and that's what you do. But if you want to set up a company, an S Corp, an LLC, or the like, there's going to be requirements and there's going to be expenses. So on the worker side, workers, again, as I said, need to do the math. And remember that, see if this model works for you. And I would say the first thing that anyone on the fence or over the fence looking to jump onto the other side should consider is whether their skills are really transferable or viable as a go-forward business as an independent contractor. So what you wouldn't want to see are people who have a W-2 position and then jump over to being an IC, and then realize after the fact that their skills really don't translate to having, say, a consultancy firm, in their own name. Also, people need to look at the sacrifice of perhaps leaving W-2 work and those benefits, those health insurance and things like that. Again, while there are bills out there and there are ideas out there to create portable benefits and even to make independent contractors, fall under the purview of sort of anti-discrimination, anti-harassment statutes, those things aren't there. So when you walk out and take off your W-2 hat to go put on your IC hat, there are some things there's a lot of analysis that you need to do. The next slide's got a little more on that as well. These are some of the costs that we talk about for workers. These are some of the things you're going to need to do. As Neal mentioned back a couple slides ago, too, there are things you're going to have to provide if you're going to be an independent contractor and you want to go to a client company. And you can move ahead a little. And, these are things like, having insurance at the rates that the client companies want you to have. These are things like having, billing systems, getting your own health insurance, as I mentioned, and then realizing, and you can move ahead a little bit, Holly, on this one too, realizing too that your income now won't be stable, that it's subject to income volatility. There's going to be highs and lows and planning for that. So there is a significant amount of planning as well as looking at tax and legal advice, and these are costs that are going to be borne by the newly born independent contractor. So definitely things to look at there. And I think on the employer side, Neal, you could speak a little bit to that.
Sure. And just to reiterate a little bit on the employer side, look, this is a new world, right? Holly, you can advance. This is a new world. You're going to have to acquire talent in a different way. You're going to have to redesign some of your procurement processes. You're going to need to understand the risks in dealing with a one-man band or a five-man band. As you engage smaller entities and what kind of risks do they carry with them? They carry sort of business wherewithal risk, right? If it's a one-man band, how likely is it that they're going to remain a viable concern as you engage them corp to corp? Similarly, we're going to have to do different things around onboarding. Many of us have relied on our MSP partners or our staffing partners to appropriately vet and onboard individuals. That'll be a bit more on the corporations at this point because those folks are going to be different than the traditional staffing providers. And then lastly, the benefits that accrue to the individuals that Rob went into great detail about, they to some extent accrue to these large employers as well. And we're going to need advice from our tax partners and our legal partners on how to best take advantage of those changes and how to safely engage these small entities. All right, next slide. I think this is you, Rob.
Yeah. Take action now. Right out of the lawyer's mouth. We always a little bit risk adverse here. So what do we do? What do you do sitting here listening? Empty out. I would suggest right now, emptying out all your cupboards, your cabinets, everything you do that relates to the contingent workforce, to independent contractors, and take a look at it. Now is a great time to review. Make sure that your contracting requirements are where they need to be. As Neal mentioned, there's going to be, I think there will need to be some adjustments for these smaller, more, mom and pop type of independent contracting outfits that you're going to need to look at. Not everybody's going to need to provide $5 million in professional liability insurance, so you really should look at job by job, buckets of jobs, buckets of risk. So you'll need to work with, your insurance advisors on that. And we don't know how many of these people are going to be out there, but we do know it's going to be a lot more. So right now, again, is the time to really just plan ahead. And be ready, too, again, as I mentioned a little while back, that you may be looked at. So some of these people who have done some W-2 work and are now doing IC work may not understand the real separation and delineation points between those two work engagement structures. So they may actually look to you almost still as an employer because that's where they come from. Be very wary of that. Obviously, you'll want to help them, but you're not going to want to take on that sort of paternal look of being an employer. So I would say be prepared for people coming with a little more naivete out to you as a contractor. So look for that as well. And then I would say another thing to do is keep in mind that many of the people that you're already engaging with, they're not going to take advantage of this. They're already incorporated. They're well compensated, so maybe they're outside that deduction area, deduction zone, and so they're really not going to come into play. So I would say focus in on that middle tier based on spend, based on what you pay them for fees, and kind of prepare for more to do with that demographic. And again, sorry to always be a lawyer here, but keep in mind that misclassification is still, a valid go-forward risk. Nothing there has changed. Also, still subject to the same enforcement policies and tests.
Rob, just to add on to that,
yeah.
Why don't you spend a second here talking about how the new incentive to make yourself have a structure doesn't really change the visibility around worker misclassification?
Yeah, great point, Neal. So again, you can't choose to be an independent contractor. You have to compliantly and legally be an independent contractor. So while you can set up, a business in your own name, this doesn't make you an independent contractor. Always keep in mind, just like the IRS or the Department of Labor, anyone looking at this, judge, there are always two prongs to keep in mind. And the first one is the work itself. Does the work qualify? In other words, is there a lack of direction or control by the client company over the purported independent contractor? So that's one thing. And then the setup of the independent contractor. And one thing to keep in mind, too, here with newly formed independent contractors is that the IRS typically does like to see a tail behind ICs. They like to see that they are set up and have a work history. They have other clients. They're not beholden to one client company for the bulk of their income. So this is something to keep in mind as well. So remember, two prongs. First, the work needs to qualify, then the worker needs to qualify as well. If either does not, then misclassification will be found. Anything else on that, Neal?
No, I think that wraps it up. Holly?
All right, thanks so much to both of you guys for the presentation today. And at this time, we'll transition into some questions that have come in from our audience, and we'll get your insights on those. So this first question came quite early on in the webcast. Art asks, how can they discriminate against certain type of workers just based on the type of work they do for the 20% deduction?
This is a great question, Art. Thanks. And there is a lot out there. There isn't an explanation as to why, and I could read you verbatim those excluded categories if you like. But certainly one to note is the one that's not named. So I gave you a list: doctors, engineers, etc. But what I didn't put was the tail end of those excluded categories are people. Includes people who rely on their reputation or skill sort of as their main product. I'm grossly paraphrasing there, but if you think about those people being excluded, people who rely on the reputation and skill as sort of their main calling card, that's almost I work with those people every day by the bunches. So for them to be excluded is kind of interesting. I've given this some thought, and I'm thinking that part of this has to do with the fact that the government is trying to create a tax break for those who, quote-unquote, deserve a tax break and not for those that, quote-unquote, may not. So they're looking at these professionally skilled people as being highly comped and they're not really interested in creating that deduction for them. Again, this isn't proven, purely speculation, and there's a lot of speculation on that verbiage.
All right, thanks, guys. We'll jump into the second question. This is kind of a two-part question that comes from Alice. She says there are IRS guidelines to who can be declared as an independent contractor. Has the new Tax Cut and Job Act changed these guidelines? There are 23 or something points. Are these still in effect?
Mm-hmm. Yes. And no to the first, nothing's changed. Yes, those are still in effect.
Just add some color there, Rob. While the IRS has published its 20 factors associated with determining independent contractors, there's some 96, I guess, other agencies that have a vote on whether or not someone is an independent contractor. In California, for example, you could be an independent contractor for tax purposes, but a W-2 employee for the purposes of workers' comp.
All right, short and sweet. Thanks, guys. Our next question jumps into a specific industry. Carol asks, what do you think the impact will be on the healthcare benefits and other benefits employees have desired?
So that's interesting, right? So as Rob alluded to earlier, one of the things that one hopes becomes true is that specific benefits that accrue to workers as W-2 workers, which are really, it's compensation, right? By any other word, become portable, so that an individual can acquire those same benefits, pay for themselves in the marketplace, pay for those things themselves in the marketplace, and only acquire those benefits they specifically want, because now they recognize the costs associated with it. What we are seeing, though, is as companies get larger, have a larger and larger non-employee pool, that their buying power diminishes, and so that their cost of benefits, specifically healthcare benefits, that are delivered to their internal employees, become more expensive to those internal employees.
All right, thanks for that.
Right, and I think that, just to add a bit, I think it's going to be really hard to, while I think that these portable benefits are coming, I think it's going to be really hard to unfurl them, kind of administer them, because it is extremely complicated to do these things with benefits for your W-2 workforce. I imagine it's going to be hard. I mean, that being said, these things are being done other places to some extent, so they can be done. I believe they will be done, but will they ever really fill in that gap that's been going on for decades here, for W-2 workers? I don't know.
All right, great. Thanks, guys. This next question comes from Valerie. Do you have information or thoughts on the trend of companies bringing back retirees as ICs?
We have thoughts. Rob, you want to cover this one?
Well, not the safest idea to do, because it looks like it can appear to an auditor as a blatant, head count move, a reduction move, and not being done for the right reason. So the law sometimes looks at the return of recent retirees as just a way to get around keeping them on as employees, and so that's frowned upon. Companies doing that compliantly should really, perhaps there are many things. You could take a break in that tenure, but the most important thing is to make sure that you bring that person back as a real consultant. What we see happen a lot is retirees walk off the job on Friday, come back 2 weeks later. Hey, how you doing, Al? And you sit down at the same desk with the same people doing the same work, and then that's an employee. So if somebody finds that, they're going to say you're misclassifying them. I mean, it could be looked at as intentional, which is the worst type of misclassification, right? Even if it wasn't intended to be intentional. So be very cautious if you do that. If you do that, make sure that the person, the recent retiree you're bringing back, is truly set up, maybe has other clients, has incorporated, really does the things to look like an independent contractor and not just somebody who's coming back, as merely a recent retiree doing the same things they did as an employee. I don't know, Neal, you might have some more on that.
No, I think you covered off. We are seeing that desire. honestly, the best way to manage that is have them come through a third party. It's extremely complicated, and the optics are terrible.
Bluntly and I think honestly put.
Well, speaking of complications, when it comes to things about ICs, that transitions into our question from Larry. For current ICs, there are already a lot of hoops they have to jump through to qualify as an IC, so will this make it even harder?
No, I don't think so. I think that, again, the qualification hoops are still the same. I think for companies, it's going to be a little bit more of a dicey minefield for companies to make sure that they're really not wasting their time, not spending their time with people who aren't honest to goodness independent contractors, people who've just incorporated but really have no other clients but you. That's the real one to look for. If they're brand new and you really would like to see them have at least a pipeline of clients and things like that. But the hoops are still going to be the same, and that's those two pieces. Remember, the work has to qualify, be devoid or very minimal on direction and control, and then the worker themselves has to have a structure. Even if it's a sole proprietorship, they have to have a structure that indicates they're an independent contractor, and typically that's things like investment in themselves, business tools. Everybody probably knows all that. Other clients think things like that. But yeah, I think the hoops remain the same.
All right, thanks so much for that answer. Next, we'll take a question from Tanya. What do you think could be the implications of a decrease in tax revenue, generally speaking?
Well,
right. Yes.
That's a tough question. I think the implications are sort of twofold. One is I think you have a general reduction in discretionary spending, but so much of the budget is structural that I think frankly what ends up happening is you just run deficits, and you can have whatever view you want on whether or not deficits are inherently good or inherently bad, but I don't see us doing much differently on the spending side.
All right, thanks so much. How about a question from Tim? For other clients, do they have to have revenue with other clients or be able to show a pipeline of clients?
Yeah, understand that all these reviews, when it's looked at, are a totality of the circumstances review, to kind of coin a Supreme Court type of phraseology. It's many shades of gray. So either one of those two things is good for proving that someone's an independent contractor, one of many factors, right? Better to have actual clients than prospective clients, but both of them are better than having no pipeline at all, if that helps.
All right, cool. Sounds good. We'll now move to a question from Libby. How do you see this changing how our company finds talent?
Well, I think as the sort of slide illustrated, I think more and more of our non-employee workforce is going to come from these small businesses and other SOW providers. It's no longer reasonable, right, to pay McKinsey millions of dollars for activities when sort of former McKinsey folks can do it themselves and help you there. And I think traditional staffing is going to be more relegated to a role of sort of temp help. So that space in the middle is, I think, where strategically you're going to want to acquire talent. That said, I think the efforts that large companies made in the late 90s and early 2000s about getting a hold of their contingent labor will now apply to the SOW spend. So we're going to start seeing an expansion of MSP services and the footprint for VMSs.
Yeah, and I'll add that I think that certain forward thinking or more risk-adverse companies might start thinking about, instead of engaging that one or two very highly compensated and sought after resources as independent contractors, they might do take a flyer on a few of these newly formed independent contractors out there, in a compliant way, of course, but, and maybe you kind of see if maybe 4 of these smaller independent contractors that you could pay less can get done, or you wouldn't have to fight for them the same way you do for those really, really top-tier talent. So again, with that influx in that middle area of independent contractors that will qualify for that deduction and will be there for you, some companies might want to kind of look a little more, be a little more on the edge here and say, you know what, can we get this done with this set of people, even though they're a little newer, they don't have that reputation, instead of going to the one person here who calls all the shots and basically tells us what to do. So I think there could be a little interplay and a little view to that as well.
All right, great. Moving right along, we've got about 5 more minutes. So folks, if you haven't submitted questions, please go ahead and do those with the time that we have left. So let's talk about possible improvements and changes. We have a question from Lamont that asks, how do you recommend we go about revising our contracting requirements?
So I'll start, Rob, but I think you should finish. We have spent a lot of years on the procurement side building out contracts that protect our companies from all sorts of things, right? Worries about insurance and worker classification liability and company wherewithal and credit checks and so on. All of those are great when you're hiring a large consulting firm, right? They have no problem meeting those minimum requirements. The issue you have is that small companies can't, right? They can't get, $10 million in E&O. They can't pass a credit-worthy check like that. They can't sustain 180-day payment terms. So if you want to engage these middle-sized and small-sized companies, and I think you need to, if you want to engage them, you're going to have to create a variable standard of contracting based on the risk that these firms genuinely represent, right? If you hire Cognizant to do a full build-out of your back-office infrastructure, you need to have very high levels of liability associated with that contract. But if you've got a guy who's going to advise you on the best way to market to Hong Kong, it's unreasonable for him to have that kind of E&O, and it's unreasonable for you to ask. Rob? Right,
and I'll just add to that, make sure that you have really solid terms in your contracts, your independent contractor agreements that really call out and are consistent with the nature of your guys' relationship, not employer-employee type of language, but independent contractor and client type of language. I see a lot of ICAs, independent contractor agreements, that have in there really dangerous minefield pothole language that's straight out of employer-employee type of language, and it shouldn't be in there. So, we'll strike that out. So I would say, what Neal's saying is exactly right on that end. And as always, make sure that you've got yourself a nice ironclad agreement that doesn't have any ambiguity about employer-employee versus client and IC.
One other thing to consider is that we get a little used to the idea that people who work for us, when they work for us, that the intellectual property that's developed by them in our employment belongs to us as business owners, right? That is not true for an IC, and that language needs to be pretty specific in the agreement.
It does, and California in particular has a couple potholes there to be cognizant of if your contracts are in California.
All right, thanks, guys. And it sounds like that information has prompted a similar question. This one comes from Ellen. Do you recommend we reevaluate our existing contractors right now? Maybe there's a reason to wait?
Interesting question. Go ahead.
Yeah, so we don't recommend sort of a blanket reevaluation of all your contractors. So that's a dangerous little game to play. If you've been not particularly vigilant, what you've effectively going to do is create a class of folks that have been employees to you all along and who now want to come and get your stuff. That said, there are natural points of evaluation that can make sense, right? When a particular SOW is exhausted, when money runs out on a PO, calendar year change or some other natural event, and not as a full blanket of your population, but on a case by case basis, you're not going to create more risk, and you're certainly going to alleviate risk. That said, the sooner you evaluate, the smaller your carrying liability will be associated with worker misclassification. Rob?
Yes, I agree. Start doing it, those natural trigger points, but start doing it.
All right, great point to end on there. So guys, we'll go ahead and let that take us to the bottom of the hour. We'll close with one more thank you to Rob, Neal, and everyone at TalentWave for helping to support this webcast. And so for all of us here at HCI, thanks for being here.